Thank you all, and have a seat. Tisdale's present, all counsel present, the jury's outside. Okay. Ms. Aldona, you speaking for the defense?
Yes, sir.
Okay. You ready to have them come in?
Yes, sir.
State ready to have them come in?
Yes, sir.
Okay, if y'all please be as quiet as you can in here, please. If you have any cell phones on, if you wouldn't mind turning them off. Be as quiet as you can so as not to distract the jury or counsel. Okay, Ms. Aldona, I think we're ready. Thank you all very much for bearing with us. Welcome back. It's now Ms. Aldonia's opportunity to speak to you all, so if you'll please give her your attention. Ms. Aldonia, when you're ready.
Thank you. Good morning, ladies and gentlemen. Good morning. Ms. Miranda, you can assist. On behalf of Eriese Tisdale and his team of attorneys, we thank you. We thank you for the last several weeks of your time and your careful attention to everything that has been presented to you. We understand the hardships it's caused on you. However, we are now at that stage of the proceeding where we're going to ask you to give us a little bit more. Because over the last 6 weeks, we've been telling you, don't talk amongst yourselves. Don't talk amongst yourselves. Don't talk amongst yourselves. And then the first phase ended, and we told you to go talk amongst yourselves. And you came back. And we talked about in jury selection, if we went to the second phase, based on your verdict, then I would be speaking to you again. But we are at that juncture. We are at the second phase. And now we're asking for you to walk with me through the life of Eriese Tisdale. We are going to ask you at the end to recommend a life sentence. And as you shift gears, because we've already decided guilt, we're going to ask you to set aside for a moment how we got here. And let's walk through Eriese's life before that horrible day on February 28, 2013. Charmaine Tisdale and Eriese when he was a young boy. Toddler. You heard from her. Eriese, 4 years old. Just a young boy living with his single mom. Eriese with his cousins, Lauren and Ahmad. Happy times. His life has been documented. We move up to when he's 9 years old in 3rd grade. Limestone Creek, 3rd grade, class picture. It's where you start to see a little bit of the adversity that he's had to encounter as being one of 3 minorities in his elementary school class. However, he, living in a single-family home, is happy. He helped in the community. And went on to middle school, and he graduated middle school. Happier times. We heard that he was a happy kid, and that he had Rajan, a role model in his life, a male role model, because Eriese didn't have a father. And Eriese graduates from high school. The survivor charter high school. And then we get into his young adulthood. And we see where Eriese is starting to make his own statement and who he is. And then he goes to the photo shoot, the album release. He gets into his rap and his music and his passion. And you see, this is who he's becoming. Still happy. And then life continues on with his girlfriend Jessica and his little baby Zamar. All of which happens after February 28, 2013, while he sits in Martin County awaiting trial for first-degree murder. And then we see that we had Zamar, his 2-year-old son. You saw the video of him yesterday, whom he's being cared for by his mother, Charmaine. We have the 3 sisters, the 3 musketeers, that love and care for Eriese, and have been in his life, his whole life. And then we have Eriese. These are all the sides of Eriese Tisdale. The sides of Eriese Tisdale that make him up, that make him a person. So when you look at his life, his circle of life, the people that were in his life, you have to ask yourself, how did these things happen? How did we get here? How did we end up in the circumstances that we are in today, with you deciding whether to recommend life or death for Eriese? It's a formula. It really is. Because you're going to take the makeup of Eriese Tisdale, where he comes from, a young black man, struggling to find himself, to find his identity, to make himself successful, to educate himself, who struggles with the issues of who he is and his identity. He wants to move on and be in the music industry. He's very passionate about rap and lyrics. It's artistic. However, how he sees society and how he feels society sees him gets in the way, and he struggles with that. And when you put him and all those things into the formula, that's where you get the outcome, the bad outcome that happened on February 28th. The adversities that he encountered from birth all the way up to the tragedies in his life are what make him up. It is the roadmap of Eriese's life that we're presenting to you here today, because it is Eriese's life that is in your hands. Eriese did come from a broken home. Not a broken home in the traditional sense, but in a broken home in which he chose to internalize his thoughts of the world around him and how he was perceived. And when I say broken home, we're talking about when somebody loses the direction and moral guidance of his family. He did not have a father. He didn't have positive male role models. He didn't have somebody to guide him, to show him by example, this is how you are to be. Coming from a broken home, Eriese lost his moral compass. And when he lost that moral compass, All these factors came into play, and that's what happened here. And Erice's life shows you that, and we're going to walk through that some more. He had struggles as a young adult. Keeping a job, improving himself. He had the stress of the baby on the way. None of the stuff that we're presenting to you today, none of the stuff in Erice's life, what makes him up, excuses his behavior. That is not what we're here today to tell you about. If there was an excuse, we would have talked about it. And we wouldn't be here, because penalty phase wouldn't have existed, because it would have been a valid offense. So this is not about excuses. So as we go forward in this journey of Erice's life today, remember, we are not making excuses. What we're trying to do is give you a guide, so when you go back and deliberate, you understand the makeup of the person that you have to make the decision whether or not that person should live in prison the rest of his life, or he should get the death penalty. Because that recommendation is going to come from you as individuals. Now, society is full of culture. It's full of religions. It's full of race. It's full of the makeup of every which kind of person you can imagine. Erice is one of them. He's unique, as just as much as everybody else is in this entire world. Fear is also a part of what society brings upon individuals and the environment that they live in. And we're talking about that. We're not talking about society in general and why somebody that lives on the wrong side of the tracks, how he makes it, and somebody that doesn't make it, that's the choice they make, therefore they should die. The decision that you have to make at the end of the day is a serious decision. It will be probably the most important decision and recommendation that you ever make in your entire life. So we're not comparing Erice, in a sense, to the bad choice that he made that day. We are talking about moral culpability. We're not making excuses, but we're certainly not saying you group him in a group over here, and because all these people over here, whether they had adversities, whether they were poor, whether they weren't given, the traditional home with parents and siblings, they made choices. Not everybody that has the picket fence goes out and commits murder. No, we know that. We're very aware of that. But what you're going to do today is you're not here to compare him to what others could have done, because you're looking at the makeup of Erice. Why did Erice get to the point where for 1 minute and 48 seconds of his life took the life of another man, a man that was honored in his lifetime and loved in his lifetime, and he took his own life as well because he removed himself from society. That 1 minute and 48 seconds of his life changed the life of many. So we talk about racism and the stereotyping that goes along with that, and the profiling that goes along with that. And we talked about that in jury selection. And why did we talk about that in jury selection? Because we wanted to make sure that we had a jury that was educated as to what the world is still made up of. And why do we think that it's real? And why did we present it the way we did? Because we brought you a real young man, black, with dreads, to talk to you about why it's real. So when it's presented to you as that's a bunch of bull, this case is not about racism. Nobody's saying this case is about racism. Nobody's saying that racism existed in this case. But it was the events that occurred in Eriese Tisdale's life as a black young man with dreads that brought him to that day when in that 1 minute and 48 seconds, Gary Morales lost his life at the hands of him. So in order for you to understand, when you're making your decision, you have to understand that racism did affect Eriese Tisdale. And how do we corroborate that? How do we not just say, oh, it's a weak argument? Because Ahmad Carlson sat here, a cousin who knew Eriese, a cousin who lives in the same world as Eriese, that says it still exists. And if you don't think that's real, Ahmad told you that he was lucky. He was lucky. But he also told you he pretty much was taking the same path as Eriese. Had some education. Chose to wear dreads because it's what makes him up. But he told you he has his own personal experiences with racism. And he struggles with it still, every day, the profile. We have a doctor that comes in here to educate you. He educates you because the studies show that in society today, racism is still prevalent. That's all. He's just making sure that you understand when you decide the fate of Eriese Tisdale, that you are fully informed as to the world in which he lived in and how he perceived his world before you decide that death is the only recommendation. Because you only have two choices, and both of the choices take Eriese out of society for the rest of his life. One, life without parole in prison, where the only way he leaves is when he is dead in a casket. Or two, by the death penalty, which is lethal injection. Those are the two options you have based on the crime. That's the consequences that he has to live with the rest of his life. Now, Ahmad also told you that, he carries a gun for protection from the streets because that's the world he lives in. And that's the relationship between him and Eriese, that they talked about it. The profiling. They had many stories, and they're aware of it. How they funnel it is internal with your own makeup. They're unique in each other. They both have dreads, they both are black, they both basically the same age, they both want to be successful. Ahmad said he was lucky. He was given an opportunity to work, and he still has that job, and he's had that job for 8 years. Well, Eriese didn't have the same exact path, because Eriese made some choices, and he's having other struggles. Ahmad also testified that, Eriese himself was a good person. The judge is going to instruct you. There are no free homicides. We get that. When you decide this case, as far as your recommendation, we are going to go through what moral culpability mitigation that you should look at when deciding that recommendation. You must make a decision if the most horrible imaginable thing that Eriese did, that this evil act that he committed on February 28, 2013, should continue to cast evil, or let the evil die. That is in your hands. This tragic act by Eriese is not who Eriese is. We're going to discuss many mitigators. Many mitigators. But the thing that could cause you to vote for death is the thing. The thing, the elephant in the room, the thing so important to all of us in this room, all of us in this community. That thing is it's a law enforcement officer. And we talked about that in jury selection. It's a law enforcement officer that was killed. And if you don't think that's an emotional thing, then you're wrong. Because it is. And everybody should realize that's what it is. Because it is a law enforcement officer. And society is in trouble. If it doesn't want to protect its law enforcement officers. But I'm going to ask you, when you go back into that jury room, you've got to say, we've got to decide this recommendation, this individual recommendation on the law. And the fact that a law enforcement officer was killed on that day. It is an aggravating circumstance. Yes, it is. But you must consider the mitigating circumstances. Because an eye for an eye makes the world blind. And we're asking you not to be blind in this. We want you to keep an open eye when you're making your decision and you're talking back there as to what Eriese Tisdale's life has brought him to. Now, does human nature come into play? We talked about that a little bit in jury selection. Might have been Mr. Glenn or Mr. Manship, but one of us, I think, touched on it. It's human nature to want to hear certain things in a trial. It's human nature to let your emotions come in a little. But there's some things that we have to just get out. Because we don't really get to have a communication back and forth at this point, like in jury selection where I got to get an answer from you. So now I'm kind of just, don't want to say lecturing you, but I'm just informing you. But sometimes we have to just get it out. Victim impact. It's there. It's huge. It should be. It's another thing that's going to be instructed on. And we talked about that. And if you remember in jury selection, at the end of my jury selection, I asked each and every person that was left in the bunch if they could listen to the victim impact, take it in, funnel it, feel for the family, because that's human nature. And we're not asking you not to have done that. But then there's going to come a time when you have to set that aside and not let it affect your recommendation, because the law, as we drilled in you at jury selection, says that you can't consider it. It's not an aggravator. As much as we would want to think it should be or would be, you must follow the law, and we're going to ask you to follow the law. Well, I'm going to ask you another favor when you get back there, because there's a bunch of you. And your individual thought process is going to come into play, because this is an individual recommendation. I need somebody back there, somebody, out of the 12 of you, when somebody says, we need to give him death because of the victim impact. We got to. I need somebody else to stand up and say, hold on. We have to follow the law, and the law says we have to set it aside. Because that's fair and just in your recommendation. Okay. Let's talk about the law. You must follow the law as it is set out in the judge's instructions. It's clear and simple. You're going to get them. Not only are you going to get them, each one of you are going to get it. You know why? Because it's individual. And we don't want you passing it around, because we want you to sit and focus on what you feel and what you rendered and what you came up with for your own recommendation. And we don't want you waiting in line for a set of documents that instruct you on the law. Now I can use my little clicker. Once the guilt phase is over, your consideration must start out at a sentence of life in prison without parole. I just went over this. You have heard victim impact evidence. This evidence was presented to show the victim's uniqueness as an individual. However, you may not consider this evidence as aggravating circumstance. Your recommendation to the court must be based on the aggravating circumstances and the mitigating circumstances upon which you have been instructed. And you're going to get all of them so you understand. And the instruction itself also has the victim impact evidence instruction in there, which you can review again. However, it may not be considered. Now, Mr. Backendall went over the doubling, which is what this instruction is. It's also in the instructions. And the doubling is basically two or more of the aggravating circumstances are proven beyond a reasonable doubt by a single aspect of the offense. You are to consider that supporting only one aggravating circumstance. That's just the law. The fact that the incidences we have, the 4 aggravating circumstances that you're being presented with, that 3 of them involve law enforcement office activities, duties, all of them are to be considered supporting only one. Hold it, cutting. And at the end, if you find the aggravating circumstances do not justify the death penalty, your advisory sentence should be one of life imprisonment without the possibility of parole. Now, what else does that tell you? The mitigating circumstances must be considered. We've drilled that into you in jury selection too. You have to consider them. What are mitigating circumstances? Any aspect of Erice's character, background, or life. Erice's, okay? Because you're deciding whether or not Erice lives or dies. Okay? So it's about Erice and his makeup, his character, his background in life, which encompasses everything about him from birth all the way up until as he sits over there throughout this entire process. You can consider when making your recommendation. All of that reasonably may indicate that the death penalty is not an appropriate sentence in this case. All of it gets to be considered. You get to weigh everything I present to you. Everything. But remember, it's not a mechanical process. That's in the instruction. That's why we want you to read it. When I say it's not a mechanical process, it's not a scorecard. Remember we talked about that in jury selection. You don't go, oh, they got 4 aggravators and you got 2 mitigators, so 4 is more than 2, so he dies. That is not the way it works at all. It's not a mechanical process. Remember, you could have 2 mitigators and 4 and still choose life. That's the law. And we learned a lot about the law in jury selection, but we still are giving you the law because we know that sometimes you need to go back and refer to it. Because at the end of the day, you have to own your recommendation. Your individual recommendation goes home with you, even if nobody else knows what it is. So, individual decision to make by each and every one of you here today. Your verdict, you need to know whether or not it will be anonymous. And how do you know? It's in the instruction, okay? So I'm just going to read what happens back there when you're deliberating, because I think it's important for you to know. A majority of the jury by a vote of, there's 2 spaces, advise and recommend to the court that it impose the death penalty upon Eriese Tisdale. So upon a recommendation of death, you have to put in how many recommendations for death to how many recommendations of life. Okay? On the other hand, if by 6 or more, the vote of the jury determines that Eriese Tisdale should not be sentenced to death, your advisory sentence will be. You notice there's no lines. So if 6 of you choose to recommend life for Eriese, when you consider all of the mitigation against the aggravation, and you weigh it, and you make your decision individually, the jury advises and recommends to the court that it impose a sentence of life imprisonment upon Eriese Tisdale without the possibility of parole. 1 or 2. You just need to know that when you're back there. And you're deciding and you're recommending and you're talking to one another. And you're weighing all the mitigators and you're going through Erice's life and you're trying to decide if his life should be taken or not. Because we already know he's being removed from society for the rest of his life. And you need to decide if that's not good enough, based on the aggravators and the mitigators. However, regardless of your findings, regardless of everything you consider, regardless of everything that's happened in this case, regardless of all your feelings, your emotions, your beliefs, regardless of the aggravation, the facts, regardless, you are neither compelled nor required to recommend a sentence of death. That was the law that we learned in jury selection. And we came a long way in jury selection because in the process of jury selection, most people had the understanding that if you were found guilty of first-degree premeditated murder, the only sentence was death. And as we educated you through the process, everybody came to the epiphany, oh my gosh, that's not automatic. And that's why we're here today, after the 12 of you made the decision, the unanimous decision, that Eriese was guilty of first-degree premeditated murder, which was a fair and just verdict. We've moved on to the second phase, and now we're here to explain to you the law is different in the penalty phase for his sanctions. But regardless of your findings, you are neither compelled nor required to recommend a sentence of death. It is not mechanical. You don't go back there and do numbers. It's not a numbers game. It's a sufficiency game. What is sufficient to you? Does the makeup of Eriese Tisdale, is there one thing about Eriese Tisdale that makes you say, he doesn't deserve the death penalty? He doesn't deserve to be out in society ever again. But that decision's already been made. So it's either one or the other. Life in prison without parole, or he dies. Or lethal injection at the recommendation of you. Now, I want to talk to you about Eriese Tisdale's mitigators for life. As I said, the law instructs you that it's a weighing game. And I use the word game, but I don't mean it's a game because it's nothing to be considered to a game. I mean, this is someone's life. And we already know a man's life has been lost already and taken from us. The first mitigator, statutory mitigator, is age. Eriese was 25 at the time of the offense. That's for you to consider. Erice's mother was drug dependent during pregnancy, and he had tremors as a child. Now, as I go through these mitigators, I put on a notation underneath each of the slides the person in which testified as to these mitigators. Now, mitigators, to define mitigators, once again, are anything that makes up Eriese. Anything in his background, his character, anything in his life that you can assign some reason to. And we have to prove to you by the greater weight of the evidence. That means, more likely than not, it's a true fact. And it's something that makes up Eriese. And that's what got Eriese to the tragic day where this horrible, horrific act happened. Okay? Now, does everybody wake up born into this world or with a mother that was drug dependent during pregnancy? No. Does everybody as an infant have tremors? No. This is just the beginning of Eriese's makeup. Those are the things you're going to consider when you decide whether or not you recommend life or death. Eriese is a devoted son to Charmaine. Now, I go kind of all over the place when I did my slideshow because I didn't want to just sit down and just talk about infant stuff and up. Charmaine and Eriese have a loving relationship. That was brought out for the testimony. Also, Eriese is a loving father. How do we know that? His son was born while he's been sitting in Martin County Jail awaiting trial for murder. And you got to see the little video of his interaction with his son. Let's keep it real. That was a loving relationship that is never going to get more than what you saw if he gets life in prison without the possibility of parole. But you saw the interaction. Eriese has a good sense of humor. Holly Beer, Aunt Vanessa, Aunt Noretta. This started in his early childhood. Eriese is a good worker. Both of his employers came here and said that. They didn't have to, but they did. Eriese graduated from high school, Survivor's Charter. Now, part of his education shows the type of person he is. It's part of his makeup. He earned an associate's degree at Lincoln Tech. He was trying to better himself. This is not a kid that was just out there running the streets. Disregard. He was trying. He had his struggles, but he was trying, and he got some education. He had been gainfully employed. You heard testimony that he worked at Wendy's, Miami Subs and Grill, Surface Chemist, Brandsmart, Oxford, Applied Card Services, Staffing Services, and Suncoal Energy. And a couple of his employers came here and talked about him. Now I have 61 of these, really 62 when I had the last one. But these are all reasons for life. You get to assign the weight to them. But they're all reasons for life. Harris had good jail conduct, minimal DRs. We heard about them. I guess we argued about them. But you got the gist of it. We had the warden talk. He reviewed his jail records. He reviewed his disciplinary records. We heard from Dr. Cunningham. He said, everyone said minimal DRs. What does that mean? A couple of times he got instructed. He did a couple of off things. Didn't come to the door of the cell when asked. He had the one incident with the assault on the corrections officer. Does that define who Eriese Tisdale is? Does that mean Eriese Tisdale should get the death penalty because of those minimal incidents in his behavior in jail? Eriese is important to his mother, Charmaine, because he is her only child, obviously. Eriese has artistic abilities. He's a rapper, he's a writer, drawing. Now we can talk a little bit about the writing, his choice of rap. Is it for everybody? Does that mean that he's a horrible person? Does his words that reflect thoughts inside of him, his freedom of speech, does that define his actions on that day as deserving of the death penalty? He possessed positive personality traits. He worked hard. He was respectful and courteous. That's Alice Hudson, the little scientist. Remember what Alice said at the end. He needed to go do something that was more suited for him. He tried, but you know, the dreads, the earbuds, the music, walking around, it just wasn't in tune with the little geeky scientists that work at the chemist. Nothing about him, did she say, was negative. He worked hard, he was respectful and courteous, he just didn't fit in. That kind of goes to the next level of what we're talking about as well. Here he is trying to be productive, to have an employment, but it just wasn't, he wasn't able to express himself the way he really wanted to. But what he really wanted to do was be in the music industry and rap. But that's, common sense tells you, that's one of those fields that's, you better keep that as your hobby. That's what, you know, Loretta, Vanessa, they were kind of like, yeah, that's what he liked to do, but, you know, is that really realistic? Is that a practical thing? He will adjust well to prison and to life in prison. Low risk for violence, scientific research, those are big words. This Dr. Cunningham came and spoke for over an hour, educated us, let us know science doesn't lie. It wasn't just 6 inmates. There was one study that had 50,000 inmates that he was putting in a grid where Erice's makeup, factors that are important to how you're going to conduct yourself in prison, whether or not you're in fear of hurting others, whether or not you're at risk to be violent in prison, all those things, Dr. Cunningham over 20 years experience, talked to Eriese. He got the answers. He put them in. Some of the answers had nothing to do with Eriese. It had to do with his history. He reviewed his records from the jail. These aren't things that Eriese got to plan before the good old doctor came so we could give him the right answers so that he could pass, fail, get over there, skew himself. No. The doctor looked at things that Eriese had no idea he would have been utilizing to decide whether or not this particular individual would be an asset to the prison system, or whether he'd get there and hit, cause a ruckus, or be violent and give harm to others. The studies don't lie. And that's what Dr. Cunningham was here to tell you, that Erice's makeup will be somebody that would be very low risk for violence, and that's all due to scientific research. And you can't rebut that. You can't refute it. It just is. Eriese is intelligent. Dr. Garbarino, David Reedy, and Ron McAndrew, they all said that. Ron McAndrew was the warden. 22 years in the prison system. Now you, of course, get to weigh the credibility of all the witnesses. But the warden that said he had every single job from the young, 20 years early, all the way up to 22 years, that involved everything from sergeant, kitchen crew, just corrections officer in the pods, to the warden. He knew how the operation works. He knows the makeup of a person that would be productive in prison. And he said, you get a kid like Eriese in there, he's going to do well. They're going to benefit from him. 99% of the prison is run by the inmates. It's like an interview. Warden interviewed Eriese for the job. You would do fine. You would not get there and be an open population and be a danger to yourself or others. And we addressed the whole issue with the fact that there's all kinds of lay people in prison and corrections officers, and whether or not those people would be set in more risk for him. And he said the way it works is that wouldn't be the case. Eriese is resilient. Dr. Gabarino did say that. These are the things that make up Eriese. These are mitigators that you can weigh to make a recommendation for life. He had a positive disposition. Ron McAndrew and Dr. Garbarino both interviewed Eriese and both came up with that. Eriese is trustworthy. He went into homes for work with David Reedy. David Reedy, that was the son, cool energy. And he said he went from homes, from the avenues to the island, North Shore, South Shore. And Eriese was a good employee and he was trustworthy. He suffered the loss of his uncle, Uncle Bill. Now, what can you infer from that? Not everybody suffers the loss of Uncle Bill, who is his role model, a male role model. Eriese is a single with his Uncle Bill at the time Uncle Bill died. That's Vanessa's husband. When he was in high school. He was a senior in high school when that happened. Miss Miranda, I'm at a stop. Cousin was murdered 10 days after the loss of his uncle. Is that something everybody experiences at 17 years of age? The male father figure that you live with dies at the operating table. Completely surprise for the family. Tragic. They have to deal with that. And 10 days later, his cousin is murdered. Those are two very close in time instances that go to the makeup of who Eriese became after that. So we look at the early years of Eriese, the happy-go-lucky years, the years that everybody said he was happy and funny and the class clown. And we have to continue on his makeup to decide whether or not his makeup deserves to live or die. He was a Pleasant Nights kid, Mary Ann Brown said. When he was young and in the neighborhood that they lived in Limestone Creek, remember it was a low-income housing. His mother was given that opportunity through government assistance to get on her own because she was a single mother. To say that he didn't have adversities in his life, and then his mother to be a single mom and they're living in low-income housing, that doesn't make any sense. That's not the makeup of this kid. Hereditary predisposition to substance abuse and dependence. Why do we know that? Because we know that the male figures in his life, the uncle, the cousin, the mom that was cocaine dependent, the father, figures that he had were alcohol and drug dependent. Heredity comes into it. He was memorable, Holly Beer said. You remember she was the teacher, 7th grade teacher, not so far removed. She said he was memorable. She doesn't remember all of her students, but he was somebody that she remembered as being a really good kid and funny. Eriese has goodness inside of him, Loretta said. These are people in his life, people that can share with you reasons to think and consider as mitigation when you're deciding Eriese's life. Eriese can serve as an example to his son of what not to do based on his makeup. Remember the defining factor. This was 1 minute and 48 seconds that changed these people's lives forever. You saw that video with Eriese's little boy where he was doing the ABC. Eriese, that's all he's got to do is to speak between the glass as his son grows up, knowing his dad murdered a law enforcement officer. That's the reality. And that's what Eriese will have to present to his son his entire life. Eriese was raised by a single mother, we already know that. Eriese was involved in his community in Limestone Creek. There's the picture where he's with the commissioner. As a young boy, he volunteered. He had adversity as a childhood, unsupervised and lonely. That came out. Now that's part of his makeup. His mom's out there working 2 jobs, sometimes 3 jobs. She's doing the best she can. Nobody's here to place blame or anything. What we're doing is we're trying to guide you through Eriese Tisdale's life. And these are the things that affected his makeup. And these aren't things that every child has. And we're not talking about any other kid's makeup except for Eriese's, because he's the one that you've got to decide whether he lives or dies today. When he was unsupervised and lonely as an only child, that was testimony from his family. And nobody has thrown, but that's adversity. Eriese had instability in his schooling. He went to 4 schools in 5 years as a child. His mother was doing the best she could, but he had to move around a lot. That was testified to by his aunt. His mother struggled financially. They had a foreclosure at some point in time. Aunt Vanessa, Dr. Garbarino. These are factors that affect the individual that you are deciding today. Eriese was a lonely child and unsupervised, again, by Aunt Loretta. Eriese can be productive in prison with the literacy program. Now, you heard testimony from Mom McAndrew. He didn't He specifically said he does not take every job he gets. When he goes and interviews somebody for what he does, he specifically said Erice's love for reading. Erice told him that he reads as much as he can in jail. Grabs as many books as he can off of the cart and then it comes around. He's getting as much knowledge as he can. But he can be productive in prison because he can work with the literacy program and help his talents, share them with other inmates that are illiterate. They're looking for people like that in prison. Remember, this is all just about whether or not he lives or dies, and whether or not his makeup gets him there. Erice admitted to the shooting. Okay? He had a good relationship with neighbors. Mary Ann Brown told you that. Her son went off to play in the NFL as he is today. Erice didn't have that path. He had no prior violent history before February 28, 2013. That's a fact. This date, that's it. You weigh that information when you consider the mitigators. Has the love and affection of his family. Everyone said that. We heard that they communicate with him, they correspond with him, they call him while he's still in jail. He was always polite as a kid. Everyone said it. Aunt Alice Hudson, the worker, Mary Ann Brown. Erice attended church. He's spiritual. Mom McAndrew also said that that's huge. But they have values. Vanessa said that the family all does that. He's a giver, and he was selfless. We are not talking about only the one day of this incident, that 1 minute and 48 seconds that eliminated him from society. We're talking about his complete makeup and what brought him to that date. But there was good and positive things about Erice up until that date. And you have to consider those things. Mitigation is all just not the negative. It's not all negative. And if he only has negative, then you can choose life. You got to look at and balance all of it, the good and the bad, when you're weighing. That was Ahmad, the cousin that also feels as though his life is full of adversity, profiling, and stereotyping. Ahmad said that. The reality is, what we're talking about when it comes to young black males in society, it's real. And you need to know that, need to own that. And don't swipe it away and just say, oh, it's an excuse. Nobody is sitting here making excuses for that tragic morning. Nobody. But what we're saying is when you're deciding life or death, you need to consider his entire makeup. He was a likable person. He was happy. He was a silly kid, funny and memorable. He was punctual, focused on tasks, communicates well with others. His father died in prison. The father that Erice never even knew. Those are adversities that he had in his life. He was Marchman acted for drugs in his early 20s. His family tried to intercede. They tried to get him. But as you know, they testified that once those tragic 2 deaths in their family happened, they noticed that Erice, he was kept to himself. He was quiet. They tried to assist him and help him. But if you also remember, Ahmad testified that he kind of was on the same path. It seemed as though all the male figures in Erice's life, and of course the 2 that died when he was 17, were using drugs. That's adversity. That's not the picket fence family, perfect. He has adversity in his life, and that adversity is what brought him to that horrible day and the actions he took. The lack of a positive role model, male. Uncle Bill, this is the set by example that we say. When kids grow up without fathers and they have no father role model and they don't have males in their life, these three wonderful women that helped raise him after 17, but before 17, this is who his role model was, his uncle. He was an alcoholic and drug dependent. This is all Eriese knew. This is his world, his environment. Nobody's asking you to go there. We're asking you to understand that this is what made him up and why he got to that day on February 28, 2013. The only other male model in his life, Rajon, who was shot and killed when Eriese was 17, his senior year of high school. Not everybody experiences that. Rajon was a convicted felon and drug dependent. And Noretta was telling us that he was trying to turn over a new leaf himself. But this is the role models that Eriese had to go by. He struggled himself with the same type of issues with law enforcement. And Noretta talked to us about how he treated law enforcement officers himself, and how he had troubles with respecting law enforcement, how he had troubles with mouthing off. This is Rajon. This is role models. Yes, Eriese had male role models in his life. But would you consider that the American dream role model? But this is what he took in, and nobody's wronging any of this. Thank you. He was creative. That brings in the rapping and the music industry. And his drafting, he got the architectural design drafting degree, his AA. He's smart. He has a positive adult relationship with family. He did have negative encounters with police and profiling. This is Ahmad. He told you the stories. I don't need to tell you the stories. The sneaker incident, is that something that happens to everybody that's a teen, a young adult? Their life was they sold sneakers in the park. People called them and they'd meet them. Is that the norm for society? Or is that something that their family did? This is all Eriese knew. But when he went to the park with his cousin to sell sneakers, got robbed at gunpoint. He's getting beat up, and Ahmad, whom we all met, was the one that saved Eriese. Eriese needed saving. Eriese couldn't stand up for himself. So Ahmad was the tough guy. But from that day on, Ahmad said that they got guns. They carried guns because they needed protection from the streets, from their world and their environment. That's the reality. That's what makes up the negative. That's what makes up Eriese. The negative encounters with police are real. You cannot discount them. What you heard from people are real life experiences. Nobody said that day was caused because of anything that Gary Morales did. It was a senseless killing of what has been described to all of us as a hero in our community. And that is extremely tough for all of us to take in and understand. However, how Eriese got there had nothing to do with Gary Morales. in anything he did that day. It was what was inside and what snapped out of Erice to get him to do that shooting on that day. He was abused by his mother's boyfriends. Lionel, the doorway, had to strip down for discipline in his underwear and stand in the open doorway for punishment. Is that normal in everyday life? Is that how all kids have to get punished? The boyfriend, Johnny, left welts on Erice. Is that normal? Or is that adversity? That's his makeup. That's all he knows. His friend Googie is shot by police, dead body left in the road overnight for 8 hours. Googie was a black man, friend of Erice. His reaction to that would seem pretty normal. Anger, upset. Who does that? Is that humane to leave a body in the road? These are experiences he had that make him up, to make him have these skewed thoughts of the way he was perceived in the world. The fear inside of Erice was real. How he reacted that day, his unreasonable, irrational, senseless as it is, it's because of what was inside of him and his life experiences. Issues of racism. Everybody talks about that. Negative stereotyping because of dreads. Everyone likes to laugh that one off. Ahmad said it's real. Noretta said she tells her boys, if you want to attract yourself attention, go ahead and wear your dreads. You should be clean cut and look professional. Be the norm. Be the norm. These kids were like, I want to show my style. That's my style. I want to do my thing. But it is real, and it's happening. It happens in society. People do profile. We talked about that in jury selection. That's adversity. He deals with that. Could he cut his hair? Is his hair cut today? Erice is going to prison for the rest of his life if he gets a life sentence, or death row if he gets a death sentence. They're going to cut his hair. He doesn't get the luxury of choosing. Boston Elementary School. Bust. There was busing going on when he was bust. You saw the elementary school. He was the only one, 3 black kids in that class. Bust to a white school. That's adversity. Can live in open population and not be a danger to himself and others. Ron McAndrews. Would be a positive contributor to prison. Ron McAndrew. Desire to work, reading skills, his hygiene was good. He can do well in prison. He is not one that any of those experts said would be a danger, a risk to others. Observed domestic violence of mother and boyfriend. Remember the incident you heard with the bat, where he grabbed his little loose slugger red baseball bat and went to rescue his mom because she was getting abused, beat up by her boyfriend. This is adversity. It just doesn't happen in every household. We're not a society that accepts that, but the reality is, in some people's homes, it happens. And he was a child of that. He was a product of a child in an environment that was exposed to things that might create an adversity to his makeup. And those are mitigation things for you to consider when making a decision whether or not he should be recommended to live or die. High potential for rehabilitation. That was from the woman that had just let him go. Just let him go. The month before this tragic shooting, Alice Hudson told him, you just don't fit in here. We're going to have to let you go. The month before. In today's society, who's paying his bills? He had the financial struggles to deal with that. He had his girlfriend that was pregnant. These are concerns that weighed heavily on a young adult. High potential for rehabilitation. That's a fact. The last mitigator I wanted to tell you was maturity. Eriese has matured over the last year. Can you come to this man? He's matured over the last 2.5 years. And how do you know that? You got to actually see him for the last month. The present, same person he was. Can you put the whole thing? Get to weigh that. Now, as we were presented with the victim impact and Sheriff Mascara was here, and we looked at the Morales girls picture, that's victim impact. I think of the Morales girls and Zamir as children that should never have had to experience the losses that they've already received. They did not deal those cards. To children, to lose their fathers is a tragedy. And it's an absolute tragedy that this young man, Eriese, sits in this courtroom, convicted of first-degree murder. But that is the way it is. And the reality is, we're dealing with it. And your job is to look at the aggravators, consider them, look at the mitigators, consider them. Now, a vote for life doesn't excuse him. It doesn't excuse the crime, his behavior. You know what it does say, though? It says you will be punished. It says you will suffer the consequences of your crime for the rest of your life. A vote for life says, we agree with the experts. Eriese will adjust to prison life, and he'll be an asset to other inmates. A vote for life says, we know this was out of character for Eriese, and we agree with his family, his friends, his teacher, his employers, that day, February 28, 2013, the early morning hours, is not all that defines Eriese. It was 1 minute and 48 seconds. His family would support him, regardless. That's what a vote for life says. Folks, you have the formula. And no matter how you slice it, this formula has a bad outcome. And your verdict today, as I said, is something that gives you the power, a power you will never experience again in your entire life. And it will end up defining you. Remember, it's individual. What you can't do, what you cannot do, is second guess yourself. Weeks from now, months from now, years from now. You cannot second guess yourself. You have to own it. Own your recommendation. Because your choice will be given great weight by the court. It is not to be taken lightly. And we know that the process has brought you here and you do not take it lightly. But do not second guess yourself next week, because it's going to be a harder week. I told you it's not unanimous. 6 of you choose life. Recommendation. It's anonymous. 7 or more choose death. You must put that down in that equation. But it's individual. Now, I have had the responsibility of Eriese Tisdale's life for the past 2.5 years. I have held it in my hand. It has been a heavy weight. And I knew at some point I would be here handing over that weight. And asking for a life sentence. My job is almost complete. I've guided you, I've told you everything you know. We are going to hand that responsibility over to you. Now each of you have that opportunity to come back into this courtroom with clenched fists of anger, or with an outstretched hand of peace and hope. There are only 2 choices: life without parole or death. We do plead for life. No one can deny the senseless murder of Gary Morales. Nobody can bring him back as much as that 1 minute and 48 seconds. Wish we could. Everyone in this room and beyond acknowledges the tragic impact that's going to echo through this community. Family, colleagues, friends of Gary's. The children of Gary Morales are now forced to grow up without their father. Their father was killed senselessly. They suffer that horrible loss. No one wishes such punishment on a child. Yet you find yourselves sitting in a room, getting ready to decide the life of another little boy's father. February 28, 2013 was a horrible page in the book of the life of Eriese Tisdale. We have tried to show you the pages and what he was like before that happened. We would like you to choose life. A little bit of mercy makes the world less cold and more just. I ask for your verdict. Thank you.
I would ask while they're moving the equipment, if anybody wants to step outside before the instructions begin, please do so now. I would ask, as a courtesy, once I start instructing the jury, that y'all wait till I'm finished, please. So if anyone wishes to leave, you're free to, but just step outside now. Members of the jury, as in the guilt phase of the trial, I'm obligated to read these instructions to you. You don't need to memorize them or write them down, because when I'm done, y'all retire to deliberate here shortly. An individual copy will be provided to all 12 of y'all when you retire to deliberate, so you don't need to memorize this or write it all down. Ladies and gentlemen of the jury, you have found the defendant guilty of murder in the first degree. The punishment for this crime is either death or life imprisonment without the possibility of parole. The decision as to which punishment shall be imposed rests with the judge of this court. However, the law requires that you, the jury, provide an advisory sentence as to which punishment should be imposed upon the defendant. It is now your duty to advise the court as to the punishment that should be imposed upon the defendant for the crime of first-degree murder. You must follow the law that will now be given to you and provide an advisory sentence based upon your determination as to whether sufficient aggravating circumstances exist to justify the imposition of the death penalty, or whether sufficient mitigating circumstances exist that outweigh any aggravating circumstances found to exist. The definition of aggravating and mitigating circumstances will be given to you in a few moments. As you have been told, the decision as to which punishment shall be imposed is the responsibility of the judge. In this case, as the trial judge, that responsibility will fall on me. However, the law requires you to provide me with an advisory sentence as to which punishment should be imposed: life imprisonment without the possibility of parole or the death penalty. Although the recommendation of the jury as to the penalty is advisory in nature and is not binding, the jury recommendation must be given great weight and deference by the court in determining which punishment to impose. Your advisory sentence should be based upon the evidence of aggravating and mitigating circumstances that you have heard while trying the guilt or innocence of the defendant, and the evidence that has been presented to you in these proceedings. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. A defendant in a criminal case has a constitutional right not to testify at any stage of the proceedings. You must not draw any inference from the fact that a defendant does not testify. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that will apply to your discussion. You must follow these rules in order to return a lawful recommendation. You must follow the law as it is set out in these instructions. If you fail to follow the law, your recommendation will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your recommendation must be decided only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits in evidence, and these instructions. Your recommendation must not be based upon the fact that you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your recommendation. Your recommendation should not be influenced by feelings of prejudice or by racial or ethnic bias or by sympathy. Your recommendation must be based on the evidence and on the law contained in these instructions. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached an advisory sentence, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the court deputy. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. An aggravating circumstance is a standard to guide the jury in making the choice between the alternative recommendations of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance which increases the gravity of a crime or the harm to a victim. An aggravating circumstance must be proven beyond a reasonable doubt before it may be considered by you in arriving at your recommendation. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating circumstance has been proven. The state has the burden to prove each aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating circumstance if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating circumstance exists, or, if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating circumstance has not been proved beyond every reasonable doubt, and you must not consider it in providing an advisory sentence to the court. It is the evidence introduced during the guilt phase of this trial and this proceeding, and to it alone, that you're to look for that proof. A reasonable doubt as to the existence of an aggravating circumstance may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating circumstance, you should find it does not exist. However, if you have no reasonable doubt, you should find the aggravating circumstance does exist and give it whatever weight you determine it should receive. The aggravating circumstances that you may consider are limited to any of the following that you find are established by the evidence. First, the defendant was previously convicted of a felony involving the use or threat of violence to the person. The crime of aggravated assault on a law enforcement officer is a felony involving the use or threat of violence to another person. Second, the capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Third, the capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. And fourth, the victim of the capital felony was a law enforcement officer engaged in the performance of his official duties. The state may not rely upon a single aspect of the offense to establish more than one aggravating circumstance. Therefore, if you find that two or more of the aggravating circumstances are proven beyond a reasonable doubt by a single aspect of the offense, you are to consider that as supporting only one aggravating circumstance. The aggravating circumstances which double one another are that the capital felony was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody, and that the capital felony was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws, and that the victim of the capital felony was a law enforcement officer engaged in the lawful performance of his official duties. If you find the aggravating circumstances do not justify the death penalty, your advisory should be one of life imprisonment without possibility of parole. Should you find sufficient aggravating circumstances do exist to justify recommending the imposition of the death penalty, it will then be your duty to determine whether the mitigating circumstances outweigh the aggravating circumstances that you find to exist. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything in the life of the defendant which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstances may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proved by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Among the mitigating circumstances you may consider are the age of the defendant at the time of the crime, the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. If one or more aggravated circumstances are established, you should consider all the evidence tending to establish one or more mitigating circumstances and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence that should be imposed. You have heard evidence from the impact of this homicide on the family, friends, and community of Gary Morales. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Gary Morales' death. However, you may not consider this evidence as an aggravating circumstance. Your recommendation to the court must be based on the aggravating circumstances and the mitigating circumstances upon which you have been instructed. The sentence that you recommend must be based upon the facts as you find them from the evidence and the law. If, after weighing the aggravating and mitigating circumstances, you determine that at least one aggravating circumstance is found to exist, and that the mitigating circumstances do not outweigh the aggravating circumstances, or in the absence of mitigating factors, that the aggravating factors alone are sufficient, you may recommend that a sentence of death be imposed rather than a sentence of life in prison without the possibility of parole. Regardless of your findings in this respect, however, you are neither compelled nor required to recommend a sentence of death. If, on the other hand, you determine that no aggravating circumstances are found to exist, or that the mitigating circumstances outweigh the aggravating circumstances, or in the absence of mitigating factors, that the aggravating factors alone are not sufficient, you must recommend imposition of a sentence of life in prison without the possibility of parole rather than a sentence of death. The process of weighing aggravating and mitigating factors to determine the proper punishment is not a mechanical process. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. In these proceedings, it is not necessary that the advisory sentence of the jury be unanimous. The fact that the jury can recommend a sentence of life imprisonment or death in this case on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you ballot, you should carefully weigh, sift, and consider the evidence, realizing that human life is at stake and bring your best judgment to bear in reaching your advisory sentence. If a majority of the jury, 7 or more, determine that the defendant should be sentenced to death, your advisory sentence will be, it's here in the verdict form, a majority of the jury by a vote of, and there's placed blanks to put the number of votes, advised and recommended to the court that it impose the death penalty upon Eriese Tisdale. On the other hand, if by 6 or more votes the jury determines that Eriese Tisdale should not be sentenced to death, your advisory sentence will be, and it's underneath that in the same verdict form, the jury advises and recommends to the court that it impose a sentence of life imprisonment upon Eriese Tisdale without the possibility of parole. When you have reached an advisory sentence in conformity with these instructions, that form of recommendation should be signed by your foreperson, dated with today's date, and returned to the court. There is no set time for a jury to reach a verdict. Sometimes it only takes a few minutes. Other times it takes hours or even days. It all depends upon the complexity of the case, the issues involved, and the makeup of the individual jury. You should take sufficient time to fairly discuss the evidence and arrive at a well-reasoned recommendation. Just a moment, you are retired to consider your recommendation as the penalty imposed upon the defendant. Mr. Kirby, if you want to step outside the jury room and smoke at any time, just knock on the door. One of the officers will take you downstairs. Now, if Mr. Bowden, Ms. St. Alot, Ms. Garcia, if y'all can wait just a minute, I'm going to excuse y'all in just a minute. Y'all's lunch should be back there waiting for you. If it's not, it'll be there in just a moment or two, and each of y'all will be given an individual packet of the instructions I just gave you for your consideration. Okay, if everybody except Mr. Bowden, Ms. St. Alot, Ms. Garcia can step down, y'all can begin your deliberations. Now you can take your notepads with you. Watch stepping down for me, please. Before I let y'all go, I want to thank you very much for your service. I know it's been a long haul for all three of you all. Fortunately or unfortunately, depending on how you look at it, we didn't need y'all to be the spare tire in the car. We didn't have any flat tires, if you'll pardon my extremely poor metaphor. Y'all are welcome to stay, of course, if you wish. You're going to be free to go here in just a minute if you wish. I do thank you, although, on behalf of St. Lucie County, the state of Florida, the United States, for serving in this case. I know it's been an imposition on y'all's time. I hope it hasn't been too much of an imposition for you, and I hope it's been an interesting experience for you. Now, if y'all want to leave and you want to hear what the recommendation is, if you leave a number with Mr. Riles or somebody, I'll have somebody call you with a recommendation if you're interested in it. If you're not interested and you just want to get out of here, you can do that too. But before I go, I do want to thank y'all for your service, and I hope it wasn't too much of an imposition on your time. Now, y'all are free, if you wish, to talk to anyone else about this case, your family, friends, anyone else if you wish. You're free to listen to read any media accounts if you wish. You're also free to refuse to speak to anyone. Some may approach you to ask you about it. You may talk to them if you wish, of course. If you elect not to, you certainly have that prerogative also. Okay? Do y'all have anything in the back room they need to get out for you? Okay, if you have anything back there, one of the officers will get it for you. Like I said, y'all are free to stay if you wish. You're welcome to go if you wish. Make sure you get all your belongings. They'll walk you downstairs to your car. Thank you all very much. You're free to go and have a nice weekend, okay? Watch stepping down, please. All right, the jury's been excused. They should have their lunch back there. Now, I'm asking, for the clerk's purpose, do y'all want all the exhibits sent back, some of them, none of them?
We would like all of our exhibits. I don't know if you should.
Okay.
Yes.
I usually do, but
We have, I think we have one or two. One.
talk about. She's asking the penalty phase or the guilt phase or,
Yeah, I guess in case they want it, they should have access to it.
okay, let's send every exhibit that's been admitted into evidence back. No court exhibits and nothing that was just marked for identification. Okay? Okay, thank y'all. If y'all will just leave a number where Ms. Elizabeth can call you and you can get over here quickly in case they have a question or something, or a recommendation. Okay, thank you all very much. We'll be in recess.